Slam dunk, are you ready to meet me? I'm here and I'm riding the fast lane. Don't let me down, I'm on fire. Does anyone else feel like a liar? It's all in your head and your mind. You just never use it.
Session 2 of the Torkin Mains Walker Courtroom is now in session. We would now like to acknowledge that we are speaking to you today from traditional unceded territory of the Algonquin and Anishinaabe people. We speak today while paying respect to the traditional knowledge keepers and the Algonquin people and all Indigenous peoples in the region of Ottawa who call the national capital their home. If you are not located in Ottawa and do not know about the traditional territory on which you are located, we encourage you to navigate to websites like nativeland.ca to find out, and we also encourage that you learn more about decolonization by consulting the TRC calls to action as a starting point. It's with great honor and privilege that I present Justice Siobhan McClelland, Intact Insurance Company, Dr. David Yerlich, Head of Clinical Pharmacology and Toxicology Division at Sunnybrook Health Sciences Centre in Toronto, as well as medical toxicologist at the Ontario Poison Centre and the scientist at the Institute for Clinical Evaluative Sciences. Justice Victoria Shore, Sheely, Justice Tracy Lyle, Nelgan O'Brien Payne. On October 19, 2021, after battling COVID-19 for 18 days, Kyla Stark died in the ICU ward of Fall View Health, 13 hours after her transfer from West Valley Memorial Hospital. Ms. Stark's medical records reveal she was in perfect health and she had no previous existing medical conditions, nor any prior family medical history that would indicate otherwise. She was double vaccinated as of August 1st, 2021. On October 1st, 2021, Ms. Stark tested positive for COVID-19 and contacted her longtime physician, Dr. Sophia Strange, and obtained a prescription for ivermectin. Though all pharmacies in her area were out of stock, Ms. Stark's condition was stable. On October 5, Ms. Stark was notified that her local pharmacy had just stocked ivermectin and a prescription could be filled. But that same day, Ms. Stark had developed severe shortness of breath and mild hypoxia and was admitted to the defendant's hospital where she was placed under care of Dr. Myrtle Papadoulis, a third-year medical resident. Ms. Stark immediately requested Dr. Papadoulis administer the ivermectin her family physician had prescribed, a course of treatment which he chose to reject. On October 6, Ms. Stark was moved into the ICU and placed on a nasal cannula during the day and BiPAP at night. Ms. Stark was treated with the hospital's COVID-19 protocol, which consisted of dexamethasone, 6 milligrams IV PO, and pure oxygen. On October 7, ivermectin was administered after Ms. Stark's family pleaded with Dr. Papadoulis. Within 11 hours, Ms. Stark's condition had improved greatly. However, the supervising physician on staff, Dr. Lutzier, chose to withhold any further administration after being informed of Dr. Papadoulis' use of ivermectin. On the evening of October 8, Ms. Stark's condition worsened, and she was sedated, incubated, and put on a ventilator. Almost immediately thereafter, Dr. Lutzier was contacted by Dr. Strange, who strongly requested ivermectin continue to be administered, in addition to MATH plus protocol. In response, Dr. Lutzier asked Dr. Strange to forward him the relevant literature for which she was relying on, so that he could make a rational decision and educated decision, which was provided immediately after Dr. Lutzier determined his time would be better spent attending to his patients than reading what he referred to as propaganda. On October 10, ICU nurse Dolores Patel was convinced by Ms. Stark's family to speak with Dr. Strange over the phone. Dr. Strange pleaded with Nurse Patel to administer the frontline COVID-19 critical care line's MATH plus protocol. Nurse Patel spoke with the attending physician, Dr. Andy Park, and convinced him to undertake Dr. Strange's request. Within 15 hours, Ms. Stark's ventilator was turned down, and Dr. Park and hospital personnel began the process trying to bring her out of the medically induced coma. On October 11, Ms. Stark's condition improved, at this point having only to rely on a nasal cannula. On the morning of October 13, Ms. Stark's family was informed by Nurse Patel that the hospital had misplaced ivermectin, but there was no need for concern as Ms. Stark was making great progress. However, Dr. Lutzier once again assumed care of Ms. Stark, and upon learning of the patient's treatment course, chastised Nurse Patel and the medical staff for administering the Math Plus protocol. Dr. Lutzier then administered remdesivir to Ms. Stark. Nurse Patel phoned Ms. Stark's family and informed them that Dr. Lutzier had assumed care and denied any further administration of the Math Plus protocol. The family was unable to reach Dr. Park, who was volunteering in Sudbury as part of an initiative to help provide critical care to patients battling COVID-19 in rural communities. At 1:27 a.m., Ms. Stark's oxygen level began to drop and she became unstable. Within 3 hours, Ms. Stark was again placed on a ventilator. The family arrived at the hospital, but was denied access due to the hospital's COVID-19 protocols in place. Ms. Stark phoned Dr. Strange and pleaded with her to get involved. Dr. Strange placed several phone calls and emails to Dr. Lutzier, but after 4 unsuccessful phone call attempts, decided to drive down to the defendant's hospital in an attempt to manage the situation in person. Upon her arrival, Dr. Strange was too denied access to Ms. Stark and was unable to speak with Dr. Lutzier. Within 6 hours, Ms. Stark's chance of survival had dropped down to 20%, and Dr. Lutzier informed Mr. Stark that he had exhausted both his courses of treatment and COVID-19 protocol in treating Ms. Stark. Mr. Stark pleaded with Dr. Lutzier to administer the Math Plus protocol and offered to sign a release, releasing Dr. Lutzier and the hospital and any of its agents and parties acting on his behalf from any and all liability arising from administering the Math Plus protocol to his wife. However, Dr. Lutzier refused to administer the Math Plus protocol, and a verbal confrontation ensued outside Mr. Stark and medical staff, and security removed him from the building. On October 19, Dr. Lutzier agreed to the transfer of Ms. Stark to Fallview Health, where Dr. Strange was on staff and would therefore be able to assume care of her. However, less than 1 hour after arriving at Fallview Health, Ms. Stark died. In this matter, the questions at issue are the following. What is the requisite standard of care for medical negligence in Canada as correctly applied to this case? 2, did Dr. Lutzier breach that standard of care? And A, failing to investigate the literature that he was provided with? And B, denying Ms. Stark treatment with Math Plus or ivermectin alone? Did Dr. Lutzier's conduct cause or contribute to the harm or injury Ms. Stark sustained? Is the hospital vicariously liable for Dr. Lutzier's action? Justice of the panel, I present to you, speaking on behalf of the plaintiff, Mr. Stark, in today's matter before the court, Gabriel Guizzo and Cassandra Eby. You are here today to determine the outcome on trial before the court on the matter between Mr. Stark, Dr. Lutzier, and the West Valley Memorial Hospital. The plaintiff's counsel will have 30 minutes total to present this arguments in court, including answering questions from the bench. The plaintiff will present their arguments first. I will signal to the court when there is 5 minutes left per speaker. The court now invites counsel for the plaintiff to begin.
Thank you. Good morning, judges. For the record, my name is Guizzo, first initial G, and my co-counsel's name is Eby, first initial C. And as the plaintiffs, we take the position that Dr. Lutzier was grossly negligent in his care of Ms. Stark by denying her access to alternative life-saving medical treatments of math and ivermectin. For clarity to the court, ivermectin is a Nobel Prize winning judge that has for decades been deemed one of the world's safest drugs. Medical discovery upon the discovery of COVID has demonstrated that ivermectin's unique and highly potent ability to inhibit COVID replication and to suppress inflammation has made it an effective treatment in all stages of COVID. And it is part of the MATH protocol, which is a treatment regimen that includes all FDA-approved medicines and vitamins. In my submissions, I will be covering the standard of care and the duty of care that should have been held but was breached by Dr. Lutzier. And my co-counsel will be talking about causation and vicarious liability of the hospital. So to start with the duty of care, it has been well established in case law that there is a fiduciary duty between the patient and the physician. In McKinnery and McDonald, 1992, the Supreme Court of Canada held that the relationship between a physician and a patient is one of which trust and confidence must be placed in the physician, and further stated that the duty of the doctor is to act with the utmost good faith and loyalty, which we are of the position that was not done by Dr. Lucier in his care of Miss Stark. Our position on standard of care. The standard of care was set out by the Supreme Court of Canada in Tur, Knutson, and Korn. In this, they state that it was settled that physicians do have a duty of conduct in their practice in accordance with the conduct of a prudent and diligent doctor in the same circumstances. And what a prudent and diligent doctor has done, and the question we do have, is what would a prudent and diligent doctor have done in a similar circumstances in regarding to Miss Stark's case? And that is what we would want to look into here and what I will present to you today. So thank you to the four discoveries that we did have of medical professionals, all a similar standing, they're able to provide clarity on the question of what that standard of care would have looked like if not breached in regards to Miss Stark's circumstance. First, we regard the issue about the investigation of relevant literature. It is agreed upon by all the doctors who were examined during the discoveries that in the standard of care and to show due diligence, the doctor in the circumstance would have read medical research if sent by a well-respected doctor of equal or greater credential, if it meant that the research could offer alternative treatment that could save a patient's life. In this circumstance, Dr. Lucier was provided by Dr. Sophia Strange, a well-respected epidemiologist, numerous medical research regarding the safe use of ivermectin and its effective use within the capacity of COVID, as she had submitted 126 studies, 82 that were peer-reviewed, 64 controlled trials, 32 randomized, 16 double-blind randomized controlled trials. Very significant and a plethora of literature for Dr. Lucier to have gone through. Furthermore, within the Knutson and Korn case, the court stated that a particular action or practice is if it's generally done by the peers of same qualifications, and then there is stronger evidence that this is the actions of a diligent and reasonable doctor. And so when looking in the discoveries, as we cited in our factum, it was upheld that reading literature provided by a doctor of that same similar credential is considered a specialist in the area.
Excuse me, counsel. Excuse me, can I ask a question here? So the literature that you say that the physician did not review, how lengthy was it? I just heard you talk about a whole lot of studies. How many pages?
I don't know the exact quantity of the pages, but yes, it is extensive in study, but there was no expectation that he would read all of them. But
okay, that was going to be my question. I mean, he has to read some of it, all of it, part of it. What is the expectation? What is the standard of care?
It's whatever that the physician themselves would usually deem reasonable. In the case of some of the discoveries, the one number provided by the physician, and please know this is kind of very subjective, would be 5 randomized controlled studies. So that was one of the options, and it would roughly take, in accordance to him, about 2 to 3 hours if you had read the 5.
So you think you're telling me that it's your view that the standard of care in this situation was for the physician to spend 2 or 3 hours reviewing the material that I think it was Dr. Strange forwarded to him?
Yeah, that is all very subjective on how long it takes to read, and that wasn't just that particular physician's circumstance, but there is a standard of care proof that in regarding to other doctors, that if it is life-saving, and this is kind of the last resort for the patient, that it is worth to at least look at some of the studies. Again, we were not expecting to have all of them read.
Okay, thank you.
Sorry, I just want to jump in there.
Of course.
Does the standard change given the circumstances of what we're dealing with COVID-19 and there being a lot of people coming into hospitals? Is the standard changing given the circumstances of this unprecedented worldwide pandemic?
Yeah, so yes, this is a novel situation, but in regards to, when discussing with, other doctors who are within a similar circumstance, who have dealt with the pandemic, they did feel the standard was upheld, that there should be a requirement of, reading up the studies if it was brought by obviously a credible and respected medical doctor who is in within that field. And Dr. Sophia Strange is, as one of her specialties is epidemiology.
Thank you.
So Dr. Lucier, in regards to the literature, did not read them. Instead, he had dismissed it as anti-vax propaganda, and which is, in our position, was completely detrimental and a breach of standard of care, as Dr. Strange is not some fringe conspiracy theorist. As I have stated, she is a well-respected doctor within the medical community and the field of epidemiology, and did provide him extensive and plethora high-quality medical research that he refused to read because it did not comply with recommendations of government agencies, and is of the view that anything contrary to these recommendations is plain propaganda. His blind willingness to hold the CDC and FDA's words as the only truth caused him to act contrary to the actions and the interests of his patients and the actions of what his other fellow medical professionals suggested they would have taken. Second, we also look into the breach of informed consent. So there is a crucial importance that to have the patient, and if they're unable to speak, the patient's family, to have a say within their treatment. In the Cuthbert and Razuli case, the patient's consent must be given voluntarily and must be informed, which requires a physician to ensure that patients understand the nature of the procedure, its risks, benefits, and the availability of alternative treatments before making a decision about the course of treatment. There are two components to this. First, in regards to the treatment, she had made it very clear that she did not want pardon my pronunciation, remdesivir, as she had stated from the beginning that is one medication that she did not want to receive. Yet it was given to her by Dr. Lucier against her clear wishes, violating that patient consent. And second, when discussing the idea of alternative options, as we are here today to discuss the effectiveness of MAF and ivermectin, the alternative option was not presented to her in any way by Dr. Lucier as an option or any other alternative outside of hospital protocol, even though Ms. Stark's family, doctor, and her family herself were pushing for further discussions about alternative medication of FDA-approved drugs. And for clarity in this, to ask something, so further clarity, yes, ivermectin, it was not created for the purpose of COVID-19, but prescribing off-label drugs is not novel. Doctors have done in the past prior to COVID. It is common practice, and something Dr. Lucier said he has done himself multiple times prior. Although physicians do have the ability to reject providing certain treatments, Dr. Lucier was not justified in preventing other qualified medical professionals from administering ivermectin or MAF, as he provided no medical evidence contrary, and would not risk his duty in his patient-physician relationship with Ms. Stark, as her family consistently reminded him they were willing to waive any liability. To further along, as I have noticed that we do have less than 5 minutes left, we see that Dr. Lucier breached his standard of care. Pardon me, as a moment of the court's indulgence. Another severe issue too, and when talking about the duty of consent, is keeping those open lines of communication. And that is something that was not done in here, not only with the discussion of alternative medications, but in general regarding her treatment, which she is in the family. And if the patient is unable to advocate for herself, her power of attorney is able to advocate for her. And there was not that opportunity to have discussions regarding the treatment that she was receiving with hospital protocol, which again, we hold the view is incredibly problematic. Allowing physicians to unilaterally determine whether the consent is required in a given case cuts against patient autonomy and the statutory objectives of providing consent. One last thing that we would want to hold is that a diligent and prudent doctor would have transferred the patient to another highly qualified, well-respected doctor if they had exhausted all their possible courses of treatment to a doctor who confidently believed that they could provide and offer life-saving treatment. Dr. Lucier breached the standard of care by not transferring Ms. Stark, as he had no justifiable reasoning in doing so and keeping her in his care. One of his reasons for preventing the transfer, that the treatment would not work, even though she was already at death's door, and a highly qualified doctor did believe that she had a treatment that through meth and ivermectin that she could help save the patient's life. And furthermore, his other reasoning with preventing the transfer was that it fell short, and which we believe fell short justification, was because that he did not want her to suffer renal failure from the meth treatment. However, he had been giving her remdesivir, which he had stated in his own discovery that one of the adverse effects is acute renal failure. Very contradictory to the benefit and the interests of the patient. To transfer a patient when exhausting all options and knowing another doctor is willing to and able to offer life-saving treatment is well within the standard of the profession. All throughout his treating, Ms. Stark, Dr. Lucier did not justify his actions with medical evidence or clinical reasoning. Instead, he allowed himself to be guided by personal beliefs and his willingness to ignore a plethora of medical information that was presented to him, and to work alongside, or at least have discussions with another competent medical professional in order to ensure the best interests of a patient. The judges here today, we are not asking you to make any scientific determinations, of course. We are asking you to analyze the grossly negligent conduct of Dr. Lucier, who went against the standard of care in the treatment of his patient, not because he's incompetent, but because he let his personal prejudices and biases delegitimize reasonable alternatives, healthcare treatment that would have saved Ms. Stark's life, all because it is socially acceptable to denounce anyone or any medical evidence that is contrary to the opinion of government agencies, that is without reasonable justification, and as a result of the pandemic, society has deemed to be infallible. Now there is a child who will learn how to walk, talk, and grow up, all without his mother. Upon no further questions, those are my submissions.
May I ask a question?
Of course.
You mentioned the positions of government agencies, and you specifically singled out the FDA and the CDC. If it's the case that they don't recommend the MAF protocol or ivermectin for the treatment of COVID-19, would it not be the case that a prudent and diligent doctor, which apparently is part of the definition for standard of care, would it not be the case that a prudent and diligent doctor would be respecting the advice of those organizations?
Yeah, so in case law, of course, the CDC and the FDA are held to, in the view of many, to be the gold standard, but they are, as I have stated, they are not infallible. And just by following what is common practice does not, in case law, does not remove the doctor of any liability of a breach of standard of care if there was alternative options, especially when it comes to saving their life, and it's not coming especially from another well-respected medical professional. I think especially being a novel situation, what we're dealing with here is there's constantly new research, and that's something we've always dealt with the pandemic. There's always updates and new things and new alternatives, and therefore, there's even a higher standard than to read new research, that when it comes to helping to treat such a novel issue where there's a significant mortality rate that's occurring.
Thank you.
Thank you.
Good morning, Justices. I thank my co-counsel who has addressed the first two elements of a negligence claim, by establishing the existence of the duty of care, and second, by demonstrating that Dr. Lucier's conduct breached that applicable standard of care. So I'm now going to move on to the issue of causation in order to demonstrate that the defendant caused the damage, both in fact and in law. And lastly, I will be turning to the issue of vicarious liability of the hospital. So with regards to the issue of causation, Clements and Clements 2012 Supreme Court of Canada at paragraph 8 summarized the but-for test. I quote, "The test for showing causation is the but-for test. The plaintiff must show on a balance of probabilities that but for the defendant's negligent act, the injury would not have occurred." In other words, as the plaintiff, we must establish that the breach of the standard of care more likely than not caused the plaintiff's injury, which is the tragic death of Mrs. Stark. So I will now go through all three of the defendant's primary failures to meet those accepted standards that my co-counsel just presented to you, and demonstrate how on a balance of probabilities, those breaches resulted in or contributed to Ms. Stark's adverse outcome. So first, when Dr. Lutzier refused to investigate the relevant literature on COVID-19 treatment options, this caused delays and potentially alternative life-saving treatment and led to a worsening of Ms. Stark's condition. Ms. Stark's chance of survival when she entered the hospital was at 90 to 98%. Yet under Dr. Lutzier's care, there is only evidence of Ms. Stark's condition worsening. Towards the tragic end of Ms. Stark's life, she was on a ventilator with her chances of survival dropping to 20%, while Dr. Lutzier refused to consider other options that could have improved her condition. As we've seen, there was a potentially beneficial alternative treatment, given that Ms. Stark was proving to respond well to MAC Plus and ivermectin when administered previously. Yet Dr. Lutzier withheld those treatments from her, causing, on a balance of probabilities, Ms. Stark's health conditions to deteriorate. The evidence is clear that Ms. Stark's condition had improved to the point where she was only relying on a nasal cannula following the MAF Plus and ivermectin, but worsened when it was withdrawn by Dr. Lutzier. So we submit that Dr. Lutzier's failure to investigate that literature and his bias towards certain treatments led to a failure to consider other possible treatments, which I highlight on a balance of probabilities could have led to improvements in Ms. Stark's condition.
Counsel, can I ask you a question there?
Yes, of course.
Yeah. So I understand the test, of course, balance of probabilities, but your argument there is that this alternate treatment could have bettered her condition. We understand, or it's my understanding in any event, that in Canada that we don't recognize a loss of chance or the possibility of treatment bettering. There's still the obligation on you to prove in fact and in law that the outcome would have made a difference. Do you feel that the evidence supports that here?
Thank you for your question, Justice. Yes, as you will see as my argument goes forward, there are three events that cumulatively the evidence does lead to that causation. As we also had in our added it to our factum, case law does also suggest that in some cases where a fault presents a clear danger, it may even be reasonable to presume a causal link. So, in the alternative, if you aren't satisfied with the evidence that I present today, we do submit that a causal link is presumed in this case, given the clear faults in his disregard for the various standard of care requirements, all three that my co-counsel presented.
Okay, I'll let you get to that. Thank you.
Thank you for your question. So moving on to the second turning point, where on a balance of probabilities, the defendant's failure to meet the accepted standard of practice caused Ms. Stark's adverse outcome. And that was when Dr. Lutzier failed to obtain informed consent from the patient or the patient's power of attorney, which would have improved the plaintiff's prognosis. So Ms. Stark had a right to refuse medication, which was overwritten by Dr. Lutzier without any reasonable justification, as we saw previously. And the foundation of a patient-physician relationship is really cemented in trust, good faith, and confidence. The medicine here was administered to Ms. Stark without her consent, remdesivir, and the largest side effect is acute renal failure. Following the administration of the remdesivir, which Ms. Stark did not even consent to, based on the evidence, her oxygen level did begin to drop significantly and she became very unstable. So I think I'd also like to highlight, just from a broader, almost policy perspective, that it is hard to believe that a doctor who doesn't respect the foundations of healthcare, including consent, could not have at least contributed to the death of Ms. Stark, who was under his care. I will now turn to the third breach that resulted in or contributed to Ms. Stark's adverse outcome, and that's when the transfer did not occur. So when Dr. Lutzier did not transfer Ms. Stark to a hospital with an equally qualified medical professional who was offering an alternative treatment, which caused significant delays in treatment. Instead, Dr. Lutzier informed Ms. Stark that he had exhausted all treatment and COVID-19 protocols. He then left her there without any solutions or additional treatments for 6 days before passing her off to Dr. Strange. We submit that if Ms. Stark had been transferred hospitals at an earlier point in time, she would have received additional and alternative treatments, which could have improved her condition, as it did during previous alternative treatments based on a balance of probabilities. In addition, based on the discoveries, for Math Plus to be effective, timing is critical to achieving successful outcomes. Dr. Lutzier caused a reduction, therefore, in the effectiveness of Dr. Strange's administration of Math Plus by leaving her there for 6 days prior to the transfer. So based on this evidence, we, the plaintiffs, submit that on a balance of probabilities, but for the breaches of the standard of care, Ms. Stark would have suffered the adverse events that resulted in her death.
So just
Can I
before
ask a
you,
question before you go to your next point? Can you just set out what the difference is between the but for and the material contribution of risk tests for causation?
Yeah, so the material contribution test is applied in very rare cases where there are multiple tortfeasors who may have contributed to the outcome. We would argue in this case that Dr. Lutzier is responsible and that this is not a material contribution case. If you were unsatisfied with the evidence, we would alternately propose the material contribution test or the fault presenting a clear danger case law option as well.
Thank you.
Counsel, before you move on, I had a question. What's troubling me, and maybe I'm just missing it, I'm missing some of the facts, but what's troubling me is whether there's any expert evidence on causation. Do you have any expert evidence you can point me to that either giving her the Math Plus protocol would have saved her life or not giving it to her caused her death?
Yes, there are multiple, there's multiple evidence in the discoveries. Both primarily from Dr. Strange, her long-term family doctor who knows her very well, that suggests that the Math Plus treatment did in fact cause Ms. Stark to improve in terms of her condition. based on the facts, when she was administered Math Plus, there was a causal link to her improved condition, whereas when it was revoked, there were worsenings of her condition. So we do definitely see that causal link in the evidence.
Sorry, Council, are you saying that Dr. Strange would be the expert you're relying upon for causation?
So Dr. Strange is one of the very skilled doctors that knows our patient very well, who has submitted very good evidence on causation. But we also do have a few studies as well in our appendices that do suggest that Math Plus treatment is an effective treatment for hospitalized patients when they have respiratory difficulties or need oxygen supplementation. So we do have that academic foundation as well in our evidence.
Thank you, Council.
Thank you so much for your question. Okay, so lastly, I will briefly touch on the vicarious liability issue. We do submit that the hospital is vicariously liable for Dr. Lutzier's actions. And we rely on the common law principles of vicarious liability. To summarize very briefly, at common law, the principle of respondent superior means that health facilities will have vicarious liability for their employees. And Dr. Lutzier is clearly an employee of the hospital, as opposed to being an independent practitioner based on the physician employment agreement, which states that the hospital employs Dr. Lutzier and that he is acting on behalf of the hospital. He also receives an annual salary from the hospital, is entitled to benefits. We therefore very clearly see that that vicarious liability employee employment relationship, and therefore submit that Dr. Lutzier's negligence caused or contributed to the injuries, and that the hospital, as Dr. Lutzier's employer, becomes vicariously liable. So in conclusion, we reiterate at this time that the evidence brought forth thus supports our submission that Dr. Lutzier and the hospital are liable for medical negligence. Accordingly, the plaintiff respectfully requests general damages, non-pecuniary damages, and an order granting the plaintiff costs. You can see the details in our factum in terms of the numbers. So subject to any questions, this concludes the plaintiff's submissions. Thank you, justices.
Maybe just a quick question, if I may.
Mhm.
So do I understand your position correctly that Dr. Lutzier's failure to administer this protocol played a causal role in the patient's death?
Yes, that's correct.
And so would it not follow that there must be good evidence that this protocol prevents death for that to be true?
Yes, and yeah, there is academic literature and studies that we pointed to in our submission, and the factum appendices that suggest that there is some evidence that Math Plus protocol in particular has been effective. However, we do recognize that these studies are still ongoing, and some of the data has been unreliable, and therefore we it is just clear that Dr. Lutzier's persistent neglect did cause Ms. Stark's condition in one way or another to worsen or fail to improve, even without kind of knowing 100% that it is 100% effective, because you don't need that scientific certainty in order to demonstrate causal relationships based on the Clements case.
Thank you.
If there are no further questions, this concludes the matter of Stark and Lutze.